the benefit is extended. The benefit which is extended includes total coverage. Suppose the ESA hospital is having only limited facility. One person is having a serious heart ailment and the ESA hospital is unable to give treatment because of lack of facility. Then the ESA doctor will refer the concerned employee to a hospital. It may be even a private hospital. And the entire expenses will be taken care by the ESA corporation, reimbursed totally. So once if you are covered under the ESA Act, entire medical expenses and treatment is taken care. And the litigative portion of it is, which come to court quite often is, there is an industry. It is covered under the ESA Act. Every month it is liable to pay both the employer and employee contribution. It has to deduct the employee's contribution and along with the employee's contribution it has to be remitted to the ESA corporation without default. Suppose if it doesn't happen and there is a default, that is one aspect. Straight default, deducting from employee, not paying my contribution also, and I remain silent. That is a total violation. Second one is, I pay contribution to my employees. I am very prompt in it. I engage contract labor or indirect labor who come to my industry, work, and I make them payment. But I don't make any contribution. Then that is a violation. Then third one is, you give work outside. I am having an industry, certain facility is not there. I will not be able to do that part of work myself. So I entrust job work to a third party. Third party will come to my premises and it will finish the job and it will return the job work to me, and for that I would have made payment. Now in respect of the straight case of non-payment of contribution, initially a notice will be issued and an inquiry will be conducted under section 45 capital A of the ESA Act, where the employer will be also given an opportunity, where the notice will be issued saying that for the period from so and so period you have not paid contribution. Therefore, what is your answer? The employer may have various reasons or no answer at all. During the COVID time, many of the employers said, we were not paying our employees, we were not running our industry, therefore the question of paying contribution did not arise. Or some were saying we were paying only reduced wages, and due to financial crunch, as we ourselves did not have any business, we were unable to pay. Then third aspect is, our industry, we have totally out of business, we are unable to pay. After hearing the parties, an order will be passed under section 45 capital A of the ESA Act. The said order can be questioned by way of filing an OP, ESI OP before the court. The labor courts in Tamil Nadu are given power to entertain the ESA OPs. the ESOP, the precondition to file a ESOP is to deposit 50% of the amount computed by the original authority. Then only the OP will be entertained. And there is a provision for a waiver. Along with the ESOP, you can file a petition saying that I am not at all liable to pay. I have said so before the authority. In spite of that, the authority has arbitrarily passed an order computing the contribution. Therefore, waive the condition to deposit 50%. That the court will consider and accordingly pass orders. Then, after this ESOP is entertained and the stay is granted, and ultimately after hearing the parties, the labour court passed the order, the remedy available is for the either party is to file a CMA in the High Court. The non-payment of ESA contribution attract interest as well as damages. So it is a very draconian provision which is by way of damages and interest. It will, if non-compliance will result in serious consequences in the long run. Then the next act is a EPF Act, Employees Provident Fund, and it applies to industry where there are 20 or more employees, and the contribution paid by the employer is 12% and by the employee is 12%. Of the contribution paid by the employee, 12% it directly goes to the Provident Fund account of the concerned employee. And the contribution paid by the employer, 8.33 goes to the pension fund and remaining goes to the Provident Fund. When you attain age of 58 years, whatever money is accumulated in the Provident Fund account will be paid to the employee directly by the EPF corporation, and pension, which is not a substantial sum, which will be ranging around 5,000 rupees a month, will be paid to the employee, and after his lifetime, if the wife survives, family pension will also be given. That's how the scheme works. And even in the EPF Act, if the contribution is not paid, there will be an inquiry under section 7 capital A, and after hearing parties, order will be passed, and that order is subject to an appeal before the EPF Appellate Tribunal. Earlier it was functioning in Delhi. Now the Central Government Industrial Tribunal from Labour Court, which is functioning in Shastri Bhavan, is empowered to entertain the appeal. Even in the appeal, like ESI, the 50% of the amount should be paid, and like ESA Act, there is a provision for waiver, and the court, considering the circumstances, has a right to waive the entire amount. Entire amount means 50% to entertain the OP, or it may impose modified condition like 10%, 20%. And the order passed by the EPFO is also subject to judicial review under 226. No further appeal, statutory appeal. And the next act is Tamil Nadu Conferment of Permanent Status Act. It is a Tamil Nadu State Act. the persons who are working continuously for 490 days with a period of 24 calendar months by virtue of section 3 of the said act are deemed to be permanent by act of law if a person is continuously employed. The adjudication forum is Inspector of Labour of the concerned jurisdiction, and the order passed by the said authority is subject to review only under 226. The Employees Compensation Act is the next act, where I said ESA Act, I will wind up. I think people are becoming restless. The problem while rushing through. Employees Compensation Act, where I said ESA is not operated everywhere, and ESA applies only where 10 people or 20 people are employed with or without power. Suppose a person is employed in a petty shop and he is injured, disabled permanently or dies, then the remedy available to him is, if he is alive, is to the Deputy Commissioner of Labour of the state government, which is now functioning in DMS Tenambe. And the act itself provides the compensation which is to be paid based on the percentage of disability, or if it is a total disability, or in case of death. It is based on age and factor which is given in the schedule to the Employees Compensation Act. And the order passed by the said authority can be challenged by way of a civil miscellaneous appeal before the Honorable High Court, but the precondition is to deposit the entire amount. Without that, the CMA will not be numbered at all. Then, and now the present position is not only compensation, interest from the date of accident till date of realization. That is also liable to be paid. Then only one more act I will wind up, that is Tamil Nadu Shops and Establishment Act. It is all mostly maintaining various registers. Litigative portion is section 41 of the Tamil Nadu Shops and Establishment Act. Now I said under the Industrial Dispute Act, only a person who is defined under section 2S can approach the Labour Court. In section 41 of the Tamil Nadu Shops and Establishment Act, there is no such restriction. So even a person holding a managerial position can approach. The only precondition is he or she should have worked for 6 months continuously. And if a person who has been working more than 6 months and if his service is terminated, without any reasonable cause, that is the word, exact word which is used in the act, without any reasonable cause and without giving 1 month notice, then an appeal can be preferred under section 41(2) of the act. The appeal before the authority will be similarly tried like an industrial dispute under the before the Labour Court. The termination may be a simple one without assigning any reason or assigning some reason, or it may be for a misconduct also after a due inquiry. In case of termination without assigning reasons, without 41 complaints, then the authority can grant any kind of relief, including compensation. Same power as a labor court. And in case of misconduct after inquiry, like labor court, he can also hold whether the inquiry is fair and proper, and once the inquiry is set aside, he himself can conduct inquiry and give a verdict. The order passed by the authority under the Tamil Nadu Shops and Establishment Act is final, like award by the Labour Court. The next avenue of challenging the order is by way of writ petition only. Like section 17B of the ID Act, now a new amendment has been brought in where the employee succeeds before the Shop Act authority can make a claim for lost on salary every month from the date of the order till the disposal of the writ petition, and the only precondition once again is not gainful employment. That's how the Shop Act works. As far as the Factories Act, Plantation Act, Catering Establishment Act and BVD Cigar Act, all are mostly regulatory in nature. And there is no litigation aspect of it. Like Shop Act in Tamil Nadu Catering Establishment Act and BD Cigar Act, the employee can file an appeal, like an appeal under the Tamil Nadu Shops Act. Now, all these acts are now there. Now, code 2020 code has come, but it is not notified. So, still the all the law which now I have been referring to still in operation. The code has been divided into 4 volumes, and all these acts which I have been now telling have been based on wages one act, based on dispute one act, like that they have compiled and they have issued, but it has not come into effect, and I don't think it is likely to come for some more time. And those code, it is nothing but just an improvement of the existing law, and it is not a drastic change. So whatever now I have said, everything finds a place in the new code also. But where I said 5B 100 employees, now they have increased to 300 employees. Like that minor modification in view of the change of circumstances. As we progress, some minor modifications have been made. Now with this I will wind up, and I think my young friends will be happy to have a weekend, good weekend.
If anybody's got any questions,
Definitely you can ask. And nobody restrict yourself from asking question. You can ask question in on the Tamil or English. Don't hesitate to ask question. சந்தேகங்கள் இருந்தா தயவு செஞ்சு கேளுங்க. கேள்வி கேட்கறது தப்பு கிடையாது. நான் ஏதாவது சொல்லாம விட்டு போயிருந்தா ஏதாவது புரியலன்னா கூட கேளுங்க, தப்பு கிடையாது.
no, down.
Anyone, ma'am?
Not here, down.
With regard to sir's topic on this litigative aspects of all these 6 legislations which we covered, any student?
நான் ரொம்ப தெளிவா சொல்லிட்டேன்னு நினைக்கிறேன். அதனால யாருக்குமே எந்த விதமான சந்தேகமும் வரலன்னு நினைக்கிறேன். அதனால கேள்வி வரல. அதனால பதிலும் நான் சொல்ல வேண்டிய அவசியம் இல்லாம ஆகி போச்சுன்னு நான் நினைச்சுக்கிறேன். எதா இருந்தா கேளுங்க. ஒண்ணு hope okay. People are hesitating தெரியல பரவாயில்ல வந்துட்டு you think about it and that's it. And nice opportunity. Tell me sir.
சார் இப்போ 11A டிஸ்மிஸல் ஆயிடுறாங்களா சார்? அப்போ வந்து ஒரு ரெமடி வந்து ரீஇன்ஸ்டேட்மெண்ட் வித் பேக் வேஜஸ்ன்னு சொன்னீங்களா சார்? எல்லா சிச்சுவேஷன்ஸ்ல பேக் வேஜஸ் கம்பல்சரியா கொடுப்பாங்களா
இல்ல
இல்ல
அப்படி கிடையாது. இப்போ நான் ஒரு கேஸ் சொல்றேன். நானும் தம்பி தான் நடத்தின ஒரு கேஸ். மொபிஸ் இந்தியான்னு சொல்லிட்டு தே ஆர் ஆன்சிலரி யூனிட் ஆஃப் ஹுண்டாய். முதல் இங்க இருந்தது. தென் ஆஃப்டர் தி கான்ஸ்டியூஷன் உட்காருங்க. ஆஃப்டர் கான்ஸ்டியூஷன் ஆஃப் காஞ்சிபுரம் லேபர் கோட் அந்த கேஸ் அங்கே ட்ரான்ஸ்ஃபர் ஆகி போச்சு. அவர் வந்து ஒரு 4-5 வருஷம் வேலை பார்த்தார் அந்த எம்ப்ளாயி. வி ஆர் அப்பீரிங் ஃபார் எம்ப்ளாயர் மொபிஸ். வேலை பார்த்துட்டு தென் ஃபார் சம் ரீசன் தே ஸ்டாப். ஐ திங்க் some employees were trying to form a union there. So and this particular person was instrumental நினைச்சாங்களோ என்னோ தெரியல. They stopped. After stopping, he also accepted. Accept in the sense what? Whatever money அவருக்கு கொடுக்க வேண்டிய பணம் இருந்ததோ அதெல்லாம் வாங்கிட்டு போயிட்டாரு. Then after some time வந்து he thought okay, அந்த லேபர் கோர்ட்ல வந்து ஒன்று முக்கியமான ஒன்று சொல்ல வந்துட்டேன். There is no court fee. If you go to any court, வந்துட்டு you have to pay court fee, then only you can litigate. Even in high court, to file a writ petition, you have to pay 750 rupees. Writ appeal 1500 rupees. Like that, for second appeal, everything there is a fee. Suit, you know, there is a Tamil Nadu court fee and suit valuation act ஒன்று இருக்கு. அதில் வந்து பார்ட்டிஷன் சூட்டுக்குனா எவ்வளோ கோர்ட் ஃபீ கட்டணும் அந்த மாதிரி இருக்கு. கோர்ட் ஃபீ கட்டாமல் எந்த வழக்கும் போட முடியாது. பட் as far as labor court is concerned, for employees approaching labor court, there is no court fee. Only வந்து வக்காலத்தில் வந்து ஸ்டாம்ப் ஒட்டினா போதும். அதுவும் அட்வொகேட் வெல்ஃபேரும் கிளர்க் வெல்ஃபேர் மட்டும் ஒட்டினா போதும். நாட் ஈவன் தட் 10 rupees கோர்ட் ஃபீ ஃபார் தி வக்காலத்தை ஒட்ட வேண்டிய அவசியம் கிடையாது. இந்த எம்ப்ளாயி வந்து பணம்லாம் வாங்கிட்டு போயிட்டாரு. அப்புறம் கேஸ் போட்டாரு. கேஸ் போட்டு வந்து நாங்களும் யோசித்தோம். இவர் வந்து பணம்லாம் வாங்கிட்டு போயிட்டாரு. அப்புறம் ஒரு 2 வருஷம் கழிச்சு பொறுமையாக போட்டார். தென் we made some probe independently. Then we found he was working somewhere. Then we found out the industry where he was working. Then we traced his PF number. PF number வந்து it will give the date when he joined that company. Then இதெல்லாம் வந்து சொல்லிட்டோம் கோர்ட்ல. வந்து சொல்லி கோர்ட்டும் வந்து இதெல்லாம் ஒத்துக்கிச்சு. கடைசியில் அவங்க வந்து என்ன சொன்னாங்கன்னா வந்து நீங்கள் வந்து 4 வருஷமா வச்சுருந்தீங்க. But you retained him only as a trainee. So we court thought as retaining a trainee, we were giving on the low wages and getting the regular production. So it awarded a compensation of 50,000. 50,000 1 lakh, 1 lakh, 2 lakhs. It's a sole discretion. இப்போ இன்னொரு ஈசாப்னு ஒரு கம்பெனியில் நாங்கள் ஒரு எம்ப்ளாயிஸ்க்கு அப்படிறோம். அவங்க வந்து என்னன்னா கொஞ்சம் ரைட்டியஸ் யூனிட். அது அம்பத்தூர் பக்கத்தில் இருக்கு அந்த இண்டஸ்ட்ரி. தே வில் ஹாவ் எ மீட்டிங் இன் அம்பத்தூர் ஓடி. அந்த அவுட்டர் டவுன் பஸ் ஸ்டாண்ட் இருக்கு. அது வெளியில் மீட்டிங் போட்டு அதில் வந்து மேனேஜரை திட்டுறது எல்லாரையும் திட்டுவாங்க. So it was going beyond a reach. Then they charged them and dismissed. இப்போ ஒரு ஜஸ்டிஸ் குமரப்பன் தான் அப்போ வந்து இதில் இருந்தார், லேபர் கோர்ட், பிரின்சிபல் லேபர் கோர்ட்டில். எல்லாம் பார்த்தாரு. he was convinced. வந்து இதெல்லாம் ஒரு பெரிய தப்புலாம் ஒன்றும் பண்ணல, கொஞ்சம் வாலிப வயசில் கொஞ்சம் துடிப்பாக வந்துட்டு பேசியிருக்காங்கன்ற மாதிரி தான் அவருடைய எண்ணம். பட் he still thought இவங்களை திருப்பி இங்கே உள்ளார கொண்டு போய் விட்டா then the whole industry will get spoiled. அப்படின்னு சொல்லிட்டு awarded a compensation of each 10 lakhs. And with that the employees also accepted and they went. தென் ஒரே இன்னொரு கேஸ் மட்டும் சொல்லிடுறேன். நீங்க ஒரு தம்பி கேட்டாரு வந்து ரீஇன்ஸ்டேட்மெண்ட் எல்லா கேஸ்லயும் தான் கொடுக்கணுமான்ட்டு. எல்லா கேஸ்லயும் கொடுக்கணும்னு தேவை கிடையாது. அதுக்கு ஜட்மெண்ட்ஸ் இருக்கு. எந்தெந்த கேஸ்ல வந்து ரீஇன்ஸ்டேட்மெண்ட் பேட்டன்ட்லி இல்லீகல் டெர்மினேஷன், அதாவது வந்து ஒரு நார்மல் ப்ரூடன்ட் மேன் will not impose the punishment of dismissal or termination, and such a kind of punishment has been suffered by the employee. Then the court finds வேலை நீக்கம் பண்ணது தவறுன்னு சொன்ன உடனே what will be the ultimate result? Reinstatement with full back wages, continuity of service. Suppose if there is some contribution by the employee for the dismissal termination, then it will be reduced. அந்த மாதிரி தான் இது ஜட்ஜ் பேஸ் தான். இப்போ நான் ஜட்ஜாக இருந்தேன்னா வந்து பார்ப்பேன், நீங்கள் ஜட்ஜாக இருந்தால் ஒரு கண்ணோட்டத்தில் பார்ப்பீங்க. ஸோ இட் ஆல் பேஸ்ட் ஆன் தி இண்டிவிஜுவல் ஆல்சோ அப்பார்ட் ஃப்ரம் லா. சம் பீப்புள் மேபி வந்து ப்ரோ லேபர் ஓரியன்ட், சம் வில் பி மேனேஜ்மெண்ட் ஓரியன்ட். அது அவங்க எந்த சூழ்நிலையிலேருந்து வராங்கன்றதை பொறுத்தும் இருக்கு. பட் பேசிக்லி வந்து எல்லாருமே வந்து கொஞ்சம் லேபர் ஓரியன்டாக தான் இருப்பாங்க. கொஞ்சம் ஏதாவது ஒரு ரிலீஃப் ஒண்ணுமே இல்லாத கேஸ் தான் டிஸ்கஸ் பண்ணுவோம். சொல்லுங்க சார். I will conclude. Thank you very much for being patient and listening.
Thank you so much, sir. That was a wonderful session. Thank you so much for taking time coming here to enlighten the students on the practical application of labor law. Now, I invite